Distinguished members of the International Court of Justice, I stand before this esteemed court today to defend the Republic of Albania against baseless accusations levied by the Republic of Alicante regarding cyber attacks. The legal issue at hand is, did Alicante violate international law by engaging in cyber attacks against Albania? And conversely, is Albania responsible for the cyber attacks against Alicante according to the rules stipulated in the Articles on State Responsibility in International Law (RCWA)? To address the first question, we must scrutinize whether Alicante's alleged cyber attacks against Albania constitute a violation of international law. The foundational principles of international law, including state sovereignty, non-intervention, and the prohibition against the use of force, provides the framework for our analysis. RCWA, specifically Article 2, established that every international wrongful act of an state entails its international responsibility. Alicante's cyber attacks against Albania, as detailed in the case, implicate numerous principles of international law. Firstly, the principle of non-intervention, that is in the Corfu Channel case, that it was between United Kingdom and Albania, prohibits states from interfering in the internal affairs of other states. Also, Alicante's unilateral cyber assaults on Albania's infrastructure flagrantly violate this principle, undermining Albanian sovereignty and also territorial integrity. Furthermore, the prohibition against the use of force, as enunciated in the Caroline case, stipulates that the use of force is permissible only in the face of an imminent threat, subject to the principles of necessity and proportionality. Alicante's cyber attacks against Albania failed to meet this stringent standard, lacking credible evidence of an imminent threat necessitating such a drastic action. RCWA Article 4 established the conditions for the attribution of conduct to an state. It established that the conduct of an state is attributed to it if the act is committed by the state's organs or officials acting in their official capacity, or if the state acknowledges or adopts the conduct as its own. In the case at hand, there is a dearth of evidence linking Alicante's cyber activities to official state organs or officials, undermining the argument for attribution. Moreover, the lack of circumstance precluding willfulness, as articulated in RCWA Article 20, further underscores Alicante's transgression of international law. Alicante cannot claim self-defense as a justification for its actions, as there is no evidence of an imminent threat possessed by Albania warranting such aggressive measures. Additionally, the principle of due diligence enshrined in RCWA Article 3 mandates that the states take appropriate measures to prevent the wrongful acts within their jurisdiction. Alicante's failure to exercise due diligence in preventing cyber activities from emanating within its borders exacerbates its breach of international law. In contrast, let us now turn our attention to the second question. Is Albania responsible for the cyber attacks against Alicante according to the RCWA? The principle of state responsibility, as outlined in RCWA, provides the legal framework for our analysis. While Albania denies any involvement in the cyber attacks against Alicante, we must assess the evidence presented and apply it to the principles of state responsibility. For this, we have RCWA Article 2 that establishes that every international wrongful act of an state entails its international responsibility. However, to attribute responsibility to Moldavia for cyber attacks against Alicante, we must establish a direct link between Albania and the impugned conduct. The burden of proof lies with the accusing party, Alicante, to provide irrefutable evidence demonstrating Albania's complicity in a cyber warfare. Additionally, RCWA Article 8 delineates the conditions under which a state breaches an international obligation. Alicante must demonstrate that Albania breached its international obligations by orchestrating a cyber attack against Alicante. Without concrete evidence linking Albania to the alleged cyber assaults, the argument for the breach remains tenuous at best. Furthermore, RCWA Article 27 identifies circumstances precluding wrongfulness, such as self-defense and necessity. If Albania can establish that its actions were undertaken in self-defense or out of necessity to protect its sovereignty and security, its conduct might be deemed lawful under international law. However, as previously we talked about, Alicante allegations lack substantiating evidence, weakening the argument for Albania's responsibility. In conclusion, the legal analysis presents demonstrates Alicante's violation of international law. Truth is unwarranted cyberattacks against Mulvaney. Conversely, the lack of credible evidence implicating Mulvaney absolves it of any responsibility of cyberattacks against Alicante. By applying the principles of state responsibility that are in RCWA and drawing upon relevant jurisprudence, we have illuminated the legal complexity surrounding this case.
Your Excellencies, I am Sofia Fuentes, and I appear on behalf of the respondent, the State of Alicante, asserting the facts and arguments on the issues brought to this honorable court by the applicant concerning the alleged violation of the prohibition of use of force through the use of cyber attacks against Mulvaney, and the legitimate reasons behind the refusal of the ONIMA investigation team. Turning directly on the first issue, Your Honors, Alicante did not violate the prohibition of use of force due to the fact that the state is not responsible for the cyber attacks against Mulvaney in August 2021. This will be proven by the model of attribution plus breach of an international obligation of Mulvaney to Alicante by the omission of the attacks by DedSec. First, we go to the attribution. The investigation made by Alicante leads the route of the cyber attack to Mulvanian citizens by a group that decided to call themselves DedSec by the action of a cyber attack. This, at first, will not constitute a violation attributable to the state of Mulvaney if Mulvaney had a different behavior. However, here is where breach will enter. Under Article 2 of RCWA, and I quote, there is an internationally wrongful act when the conduct consists on an omission which is attributable to the state under international law. This breach is an omission under two really important points. Firstly, when Mulvaney could not prevent the cyber attack created by a group of civilians under their jurisdiction, as it was investigated and proven. Secondly, after these facts were brought to light, the state will only take action if they could breach Alicante's sovereignty, which was denied. And they did not agree to this. They also put out a communication, which is important to know. Why? Because in the light of these communications made after the refusal of the state of Alicante, Mulvaney agreed to the statements of DedSec made on human rights violations. This might entail an indirect agreement on the cyber attack, which I ask the court to investigate as the representative of the respondent. Second of all, the actions of Alicante are under the exceptions of the use of force. Specifically, this is under self-defense. Self-defense can be found under the Article 51 of the UN Charter. It has three elements that have to be proven to know that we are talking about self-defense. First, we have proportionality. The action is proportional since Alicante used the same use of force to retaliate the actions of Mulvaney by DedSec. We, in this case, this state of Alicante used a cyber attack as well. Then we have the imminency, in which we have to prove the nature of the cyber attacks made by Alicante. These were made to repel and secure a non-repetition scenario, since there were threats when the video of DedSec came out. Alicante, as a nation, had to protect and retaliate as soon as possible. Finally, the necessity. Mulvaney did not collaborate. The steps that should have been followed after the denial of the breach of sovereignty of Mulvaney to Alicante should have been to do more investigation, more internal investigation, but this was not made, Your Honors. So no, Alicante is not responsible of the violation alleged by Mulvaney. Regarding the second issue brought by this court, in which the respondent refused to ONIMA investigation, Alicante had legitimate reasons to say no to the investigation that was going to start in this state. This is because In the first place, the UN is interfering in its internal affairs. Investigations into labor practices and Alitech factory fall under domestic jurisdiction because it has not been proven by um, Mulvania, since this state has failed to show real evidence towards the alleged human rights violations that Alitech has been doing, allegedly. However, it is important to note also that the UN resolution was politically motivated due to Mulvaney's presidency on the Security Council, which is why, by exposing these legitimate reasons, the state of Alicante fails to see the alleged violation to international law. I thank the honorable judges for their time and attention.